Hi besties, welcome back to my channel. Something doesn't add up for me because apparently someone was arrested at Travis Kelce's house trying to serve deposition papers, a subpoena, to Taylor Swift on the 15th of September, which I don't even know if I believe this because Taylor Swift's attorney filed something in court days before this occurred, stating that if she's forced to be deposed, she would be available. Thus, they wouldn't need a process server. I don't know if it's true, but everyone's talking about the fact this guy jumped the fence at 2 a.m. in the morning at Travis's house, and he was supposed to serve papers on Taylor Swift. But I don't know about you, but most process servers I know have never shown up at my house at 2 in the morning, and I've been served quite a few times. Bada bum with all of that in the news and more deflection occurring. I want to talk about the response that was filed by Justin Baldoni's team when it comes to her sanctions allegations for 47.1 and how this is the third time she has requested sanctions against him. And in their motion where they are opposing this, they bring up a bunch of different arguments. I don't know which ones are actually going to work, but my gut feeling is that because this law has never been tested in court, even in the state of California, I don't see a federal judge claiming to weigh in on this, given that generally speaking, when a law is passed, the court where the law is enforced is the state courts are the ones that are supposed to testing the legalities of it, and for a federal judge in New York to make a ruling on it would be unprecedented. But she did file this, and her response started, Wayfair's response started by claiming that she seeks draconian relief under a new California statute, California Civil Code 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined statutes, including FEA, and California Code 51.9 Section 47.1 authorizes an award of a reasonable attorney's fees, treble damages, and punitive damages for a failed defamation claim against a party asserting harassment claims without malice and with a reasonable basis to file a complaint of harassment or discrimination, whether the privilege and remedies afforded to Section 47.1 apply, turn not on the Wayfair party's underlying conduct, but on Lively's motive and intent, whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. And then they cited a footnote, which is testimony that Danny Greenberg, Wabi-Yumi agent of Baldoni, the former agent, gave. So what did Blake Lively tell Danny Greenberg that would have to do with actual malice because we don't have these depositions? And she has marked them as confidential. For now, they're being sealed. But we learned that she has deposed Danny Greenberg, Vivian Baker, her makeup artist, and then someone else. As explained in Section 2, A below 47.1's express language raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and a litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble and punitive. They note that this law went into effect on January 1st, 24, and it has not been addressed in a single published judicial decision. Thus, any decision by this court on the interpretation and applicability of Section 47.1 would be a first impression. Okay, first off, I have to be honest, they call this draconian relief, and they're very heavy-handed with what this is. But from a perspective of a victim of sexual assault that is not financially astute, that doesn't have the kind of people behind them, like Ryan Reynolds, to file a lawsuit that isn't wealthy and that can't afford lawyers. This law is not created with ill intentions. It is supposed to help people be free to come forward when they drafted the law. They could have overstepped the Constitution, sure, but just to be very clear, it's a delicate balance when they talk about this because this is a law that should be protecting predominantly women, and this could be by design for why Blake is doing this, by the way. But we don't want to try to take something away from victims that could actually benefit them. Aspects of the fee shifting might be unconstitutional, but the law itself may not be right. So there might be aspects of it that are unconstitutional and might get overturned. But the law itself was not passed to penalize and make it so men can't defend themselves. Blake is just abusing it. That's my opinion. She does not explain why California's presumption against extraterritorial jurisdiction does not apply to Section 47.1 when she is not a California resident. And the alleged harassment, which is the basis of her claims, occurred in New York and on the New Jersey set, where It Ends With Us was filmed. The statute and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint where the issues of liability and punitive damages have not yet been determined by the trier of fact. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motive, to wit, whether her complaint of harassment were made with malice and with a reasonable basis. Factual Determinations within the province of a jury or court on summary adjudication based on admissible evidence, no trier fact has been made. These factual determinations, which are central to their defense and will be ultimately determined in the still pending main action, although she contends that to be effective, the remedy should be imposed at an early stage. Neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complainant's sexual harassment claims are tried in the main action. So a lot of what that says, just to break it down for you, is that everything that is currently before the court is a mere allegation, and until there has been a finding of facts by the court, either by matter of law or a finding of facts by a jury at a jury trial, nothing that she has placed before the court is actually a fact. And so her allegations are only allegations, and until it's proven that they're either true or false, they're not a fact. And so what they're saying is that right now we have our allegations, and she's asking you to make a decision on the fact that she says her allegations are true, but you haven't even said if they are. The court hasn't made that determination yet. And we deserve the right to get through this process in order to make that determination. They also say that because it's never been tested in court, and because the history of the development of this and what it says this bill is for and what it includes, it doesn't include whether or not the damages are supposed to come right after a motion is dismissed or after the full judgment of a case is in place, awarding them damages. Now, it could also unintentionally prejudice a jury because it would look like to the jury, well, they already claimed that Wayfair did all of these things maliciously. And if they did things maliciously, we must believe the fact that Blake was sexually harassed. She claims that the remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing protracted legal process. And they also note that generally this is in relation to cross claims. So like they're sued by someone for sexual harassment, and then if they get countersued, that's where this is supposed to apply. And they're saying it's unclear whether or not this applies when it's not a cross complaint but a consolidated case, because Wayfair's case was not filed as a counterclaim to Blake Lively. It was its own separate case, its own separate action, and they just consolidated them into one docket for streamlining. And because she's suing him, it says neither did the dismissal of the Wayfair party's defamation claim nor an award of penalties under Section 47.1 would achieve the goal of preventing ongoing protracted litigation under the same factual issues which determine the applicability of 47.1. They spent quite a bit of time discussing the fact that part of the way that they determine if you can get these damages and if something is retaliatory is you have to go based off the motive of the person that's making the claims. Did Blake bring these claims forward altruistically because she truly believed she had been sexually harassed and because it was her experience what she had gone through, or was there a motive where she was looking for something else? And they're telling the court that part of their defense is going to be determining the fact that they believe her motive was not because she believed she was sexually harassed, but that she had a motive that was not altruistic and not brought in good faith. And they note that the court dismissed claims against Ryan and Leslie Sloan for failure to plead malice, but they did not make the same claim and dismissal for Blake. Now, why they say her motion should be denied? It's because she fails to show California's civil code damages have extraterritorial application. She fails to present new facts or laws that might warrant reconsideration of the court's previous denial. No trier of facts has found, based on admissible evidence, that Lively's sexual harassment claims were asserted without malice and with a reasonable basis. Lively fails to show, and no trier of fact has found clear and convincing evidence the malice required for punitive damages as required by Section 3294, and the plaintiff has not proven, and no trier of fact has found the actual compensatory damages required as a basis to calculate treble or punitive damages. There's a lot of different angles that they're taking, and generally, this is because they are giving the judge multiple options in terms of which one they can agree with. But I noticed that in one of their arguments, they make a comment about how the case was not dismissed based on 47.1, and the judge allowed her an opportunity to revisit, but that in that she would need to renew a motion, and it should be a fully briefed the impact of this opinion, if any, as well as the issues raised in prior briefing. It did not rule on the alleged statements that were privileged under 47.1. She now resuscitates her motion with an extensive exposition of the facts asserted in the prior pleadings. In the order, she does not cite new facts or law relevant to whether she has reasonable basis for her harassment claims and whether her claims were asserted with malicious intent. Simply put, nothing has changed since the order, and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature. So when you get an unfavorable ruling in a court, you can ask a judge to reconsider the motion. And the proper way to ask a court to reconsider is by filing a motion for reconsideration. And they're saying that rather than actually putting forth new facts and telling the court why this should be applied, instead, she's just regurgitating the same facts from her previous pleadings, and that this could be done for PR purposes to poison his view of Justin to the public. And if it is not, it's premature. fair. And they're asking the court to decline it based on first impression. And that California should be the one to make the decision on their law, not New York federal court. Their other argument is that there are no factual findings, that Lively's claims were asserted without malice and with a reasonable basis. So part of this is that she can only get damages if it's proven that she brought these claims on good faith and that she did this without malice. Their argument is that her harassment claims remain pending, and the merit of those claims, as well as her motive and intent in asserting them, will ultimately be decided by a trier of fact, a jury, or the court in the context of summary adjudication. Indeed, a centerpiece of the Wayfair defense is that Lively's claims have no merit and were inserted for improper purpose. So I don't know. This is a little bit tricky because I don't know if her motive is supposed to be reviewed. I'm not sure the way that it's written. It just says the claims have to be brought forth without malice, and then they explain sort of how malice is determined, and then they're just saying that, okay, we don't believe she brought these for the proper purposes. Their basic basis is that if you rule on this, you're effectively going to be denying our right to defend ourselves at this point, and you're going to be making a finding of facts on her motive before we've even gone through the defense. I think more than anything, they're bringing a fairly good argument here. I just have a really hard time seeing a judge in New York making a decision on a court law that's from an out-of-state law on cloudy facts of conduct that didn't even happen in California. It happened in New York and New Jersey, and there's serious questions here about whether or not this can be extended outside of the state of California and if these benefits are available to non-state residents. So, I've watched some lawyers on TikTok talk about it. A lot of them feel like the judge is not going to touch this with a 10-foot pole, and I kind of agree. I've gone through my own process of dealing with abusive sanctions and motion practice in my own court case. I've experienced what that's like, and it makes you feel powerless. Yesterday, I shared that I'm dealing with a lawsuit related to this guy named Robert Shin. I did an entire video, so I would please ask you to watch the video. For whatever reason, a lot of you are not interested in that topic, and I think if you followed the Blake case, you would be interested in that topic. And the issue is that in a court, anyone can file anything against you, and they can make really leveled claims against you. Like, I'm currently being sued by a man that is being investigated by the FBI, the USP's investigators, the IRS, and Department of Labor, and one other agency, and what they're investigating is sex trafficking and human trafficking and/or forced labor, mail fraud, bank fraud, tax evasion, etc. And there was a federal raid executed against him in July of 25, and his church, Robert Shin's church, was featured in the 3-part docuseries on Netflix, and I was a part of that, and I helped them create that docuseries. And Robert, in my opinion, has misused the court and filed documents against me to paint me as though I'm maliciously trying to harm his reputation with false claims of sexual trafficking. And I'm doing this because I want to see him die in prison. That's what he told the court, that this is proof. And wanting to see someone held accountable does not mean you actually have malicious intent. It means that if someone has committed a crime and if they're found guilty, you want to see them held accountable, and you hope that they're held accountable, their sentence in this case. I said that I hope that he passes away in prison. If he's sentenced, he could be in prison for life because he's 67 or 68 years old. And one of those counts that he's facing is up to life in prison. But if you look at my case, the way that Robert's filings are against me, it's always that I'm dangerous. I cannot be trusted. I'm always doxing him. I'm putting his life in danger. In fact, he's got his dancers convinced, or at least they're telling a court, that the reason why they've deleted all of their evidence and spoiled in this case is not because there's a federal investigation, but because I'm the reason they've left the internet. It isn't because their pastor is under investigation, right? So I know what it's like to be smeared through court documents. I've gone through multiple lawsuits where people have leveled false allegations against me in court, and it can feel really emotionally draining today. I actually cried because I'm tired. It's been 3.5 years, and I'm emotionally and mentally and physically drained. It's taken my joy. It's made me terrified to leave my home. I know that there are followers of his that will possibly go to lengths to possibly hurt me. I have dealt with doxing and harassment relentlessly. And so it's been a very emotional time for me. And so when I'm framed as the bad guy simply because I'm reporting on what's happening in the public, it's very disconcerting. It's a horrible place to be. So I have so much empathy for what Justin is going through and what Wayfair is going through. With that said, I don't know what's going to come out. I don't know if this were to go to trial, what would happen. I do know that Blake's case doesn't look strong. The way she's filing things reminds me of how Robert Shin has filed against me. The way that she's constantly doing these motions in retaliation to him reminds me of what I've experienced with Robert. And it's fundamentally why I've uncovered this case for the length of time I have. Because I can see myself in Justin. I know what it's like to be on the receiving end. And I can tell the way that Blake files that she's motivated, in my opinion, the same way that Robert's motivated to deflect from her own behavior. And for him, it's my opinion that he does this to deflect from his own behavior and to retaliate against me. So, and Unfortunately, people with money can abuse the court systems, and it's horrible to be on the receiving end of it. So my only final statement here is that all the people involved in this case are humans. We need to remember that they're going through a really challenging legal process, and no person is perfect, but always with a grain of salt. Make sure that when you're reading these documents or you're hearing it from me, that you remember that nothing is proven yet. Nothing's proven on the side of Justin. Nothing is proven on the side of Blake. And all we have right now are just a lot of mudslinging that's been happening mostly by Blake towards Justin. But Justin can give it back a little bit. It's been a big PR war, and it just doesn't look like your traditional case. And I think that's why so many of us are feeling so disconcerted or sad or frustrated with how the rulings are going and frustrated with the judge. I get it. I'm frustrated with my own judge. But, people that are narcissistic are very good at using the court systems to abuse. So we just have to hang in there and see how this is all going to play out. I don't think that the judge will rule in Blake's favor on this, but I do need your help with my case. It needs more attention. I'm really worried about the possible victims that are still being impacted in the case with Robert Shin, and I really need you guys to help elevate that. So if you could please go watch that video, leave some comments, and share. I would appreciate it. And just help me get the story out there, because I need someone that's bigger than me. Get attention to the feds. Listen, this is what we're dealing with right now. So let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.